right. Hello, everyone. It is Bradley Chaplick, and I am here doing our condominium law live stream. Once again, we're happy to that you can join us. So I'm a condominium lawyer at the law firm of Horlick, Levitt, Lella, and I'm just getting everything all set up here as we're getting started. So, if you're new to the channel, please subscribe. You can hit the subscribe button below. And we do these live streams pretty much every Wednesday. We've missed a couple since March, but we're pretty consistent on it. And we're here to talk about all your questions. A lot of the questions since we started have dealt primarily with COVID and condominiums, but we answer all kinds of questions that you have about condominium law in your condominium community. I'll just ask if you're going to put a question into the chat, which I encourage you to do, to please make sure that you don't put any personal or confidential information in the chat. Just try and anonymize the question as best you can. And we'll wait for the first questions to start rolling in. I see William saying, great session. Thank you. Oh, thank you, William, very much. We appreciate it. So some of the things we want to talk about are obviously the recent lockdown rules and what that means for condominium corporations in Toronto and Peel. And then we want to talk about some of the things that have been going on for a few months, like the legislation that was passed to protect organizations from liability if they follow public health protocols. So that legislation was pending until very recently. It received royal assent on Friday, November 20th. Hi, Julia. Julia's saying hi. And we want to talk a little bit about electronic meetings. And then we're going to talk about health screening questionnaires for condominium corporations. Make sure you're all doing your health screening questionnaires. It's required by law since September. And then finally, we're going to talk a little bit about the condominium buyer's guide. So those are all the subjects that I want to cover today. And then, of course, we'll answer all your questions. So let's talk about lockdown. And I apologize, I'll be looking away from the camera as I sort of refer to my notes here. So we send out a weekly email bulletin, and a lot of the information I'm going to be talking about is in the bulletin. So if you're not getting that bulletin, send us an email and we'll get you added to the list, because it's a really detailed information bulletin. We send it out pretty much every Monday. Sometimes it goes out Tuesday. Depends on the timing of whatever's going on in the news. We want to send the bulletin out after the announcements are made, not before, because then it's out of date. So, so if you're in lockdown, what does this mean for your condominium corporation? Well, the first thing it means is you're closing your indoor amenities, right? So you can be pretty broad in your closure. So any gym facility, any sports courts, like a squash court or something equivalent, and your swimming pool. So this is all more restrictive than what we were doing in RED, which was a modified version of Stage 3. And prior to RED, when Toronto was in modified Stage 2, you can think of lockdown as being the equivalent of what was the original Stage 1. So the first step out of the full lockdown was Stage 1, and we're basically back in Stage 1. So you're closing all your indoor amenities, and for outdoor amenities, you are only opening them if you can safely do so. And that means you have written safety plans, it's reservation only, you're keeping contact information for tracing purposes, and you're ensuring that people from different households are maintaining 2 meters distance from each other and 3 meters in the case of sporting activities. So because of the season, you might not have any outdoor amenities that are open, but things like barbecue areas, tennis courts, in better weather, those would be the types of amenities that people could have open if they can meet all those criteria. Perhaps because of the weather, they're going to be closed anyways. So that's what you're looking at in terms of amenities during the lockdown. And outdoor gatherings limited to 10 people. So again, if you have like an outdoor terrace or whatever, you have to make sure that you don't have more than 10 people out there. Okay. As you know, for restaurants, this will affect some of the Non-residential condominium corporations, indoor and outdoor, i.e. patio dining, is prohibited, so it's takeout only. And let's talk about board meetings and meetings of owners. So whereas there was previously some attitudes that under the looser restrictions you could have meetings of owners in person or perhaps board meetings in person, because if they fell within the 10-person, 25-person, 50-person limits, that it would be okay, not wise, but legal. Now in lockdown, there's no indoor social gatherings, period, and outdoor is limited to 10 people, so you're not having in-person board meetings. You're not having in-person meetings of owners. Everything should be electronic going forward if you're in Toronto or Peel. And so that means, because I know some condominium board meetings were happening like in a large boardroom with people spaced apart, wearing masks, and I would say that in Toronto that's no longer permitted. You're gonna have to do them electronically until further notice. Another issue on the lockdown is short-term rentals. So the regulation as written says that if you made a reservation before Sunday, or on or before Sunday, November 22nd, and the reservation is supposed to take place, like the actual stay is during the lockdown, that those reservations can be honored, but that you can, no new reservations after November 22nd, so once the lockdown period begins. That's going to be very difficult for a condominium corporation. So if you were going to tolerate short-term rentals at all, you would be checking the booking documents to make sure that the reservation was made legally. And some condominium corporations might just say that they're going to pass an emergency policy anyways, saying we're not allowing we're not allowing short-term rentals right now. And so that takes us to another subject. So, and the last point was real estate. So things like drop-in open houses are a no-go under the lockdown, but in-person real estate showings by appointment are still permitted. This is more advice to realtors, but you wouldn't do it if the property is occupied by a tenant. So if a tenant lives there, you wouldn't do in-person showings. You would do them virtual, basically exclusively, until the property is vacant. But if the property is vacant, then you can do your in-person showings and you just collect information for contact tracing. So the question for condominium corporations is in-person real estate showings illegal? And the answer is they're not illegal, but as a condominium corporation, you might want to make a decision whether you want to have policies that are more strict than the emergency lockdown order. And the rationale for this is set out in a case called Fraser, and a lawyer in our office, Puneet Bandal, did an excellent video summarizing the Fraser case, and it's posted on our channel, so you should watch it. It's her most recent case law corner. So if you want to know about creating policies for your condominium corporation and whether you can do it and make them more strict than emergency orders, then Puneet's video is a good answer for you. And the answer, of course, is that you can. You have to be reasonable, and you should follow certain rules, like making sure that the policy is in writing and its owners are given notice of it, and other reasonable procedural protections. And you also want to make sure that your policy is drafted in consultation with your condominium lawyer. So if you have questions about those kinds of policies and whether you can, do things like restrict visitors to the building or restrict short-term rentals or real estate showing during the lockdown, especially if the lockdown ends up getting extended, we don't know if it will, then you can watch Puneet's video or you can ask me in the chat. So before I continue on our list of things to talk about, let's just knocking some things off my notes. Let's answer Adib's question. So a newly elected board member is refusing to sign the Code of Ethics. If they don't sign the code and have no intention to, are they not eligible to participate in board meetings? Well, Adib, it's going to depend on your condominium bylaws. So as a general rule in the Condominium Act, directors are not required to sign a code of ethics unless the condominium corporation's bylaw says so. And so if the bylaw says you are required as a director to sign a code of ethics, and then we have to see what else the bylaw says if you don't. It may be that there is a consequence set out in the bylaw itself, and you'd have to take a look and see what it says. And possible consequences that might be in your bylaw, it might say that the person can't attend meetings until they sign it, or it might simply say that they can be disqualified from the board if they don't sign it. So I've seen different bylaws, and I would say just to take a quick look at your bylaw, see what it says, and then the answer should be there. And if the bylaw is silent, then we're going to have to take a closer look and see what you can do with the code of ethics. I mean, I guess on a more practical level, Adib, you would want to try to understand why is it that the director is not signing, and is it because signing the code of ethics is a choice that directors have and it's not required, in which case there's no obligation, or are they not signing it for some specific reason? You want to know. So I think you try to raise it with the person and figure out what their objection is, and look at your bylaw, and you come up with a solution. And okay, similar question, a little bit different from Catherine. What if a board member has not completed the necessary CAO training within the required 6 months and is not interested in doing so despite property management sharing the requirements? Next steps. Well, Catherine, next step is automatic and very simple. A director who does not complete the director training within 6 months is disqualified from the board automatically. There's nothing that you can do to save it or prevent it from happening. It doesn't have to be approved by any board resolution. If they don't complete the mandatory director training within 6 months, and then they're off the board. So I think that's a pretty simple consequence and clear answer to your question, Catherine. And I think really that's what Adib was asking, is does something similar apply to the Code of Ethics? And I was saying with the Code of Ethics, it depends on your bylaw. With the CAO training, it's a requirement from the Condominium Act. The Condominium Act qualifications for all directors and all condominium corporations in the province are crystal clear. You must complete your training within 6 months. If you do not complete it, you are automatically disqualified from the board. And then the board should just appoint a replacement director and say to the person, you didn't complete your training within 6 months, you're off the board, thank you very much. And then fill the vacancy and send out your information certificate update showing the constitution of your new board of directors, and make sure that the person you appoint has either completed the training before they're appointed or does so immediately afterwards. So that's the answer to your question. So follow up from Adib. What about where one board member wishes to disclose confidential board's discussions to a non-corporation approved discussion forum? What is the consequence or liability? Okay, so we're talking about confidentiality. The presumption in your question is that the thing being disclosed is confidential, and so I want to probe that presumption, because of course it's a problem if a director is disclosing confidential information, but we don't want to make a mistake about what we mean when we talk about what is confidential. So in the CCI Code of Ethics, there is a definition of what information is determined to be confidential, and you would include in that legal advice received by the condominium corporation's lawyer to the board of directors, so that is protected by solicitor-client privilege. There's also some other information relating to litigation or insurance investigations. That kind of disclosure is pretty rare. And then other confidential discussions primarily relate to specific units and specific owners of units or residents. And so in that case, the privacy obligation is that they would be breaching the privacy rights of the owner that owner's information is being disclosed. So to give a sort of mundane example, you might have a particular owner who is in arrears of common expenses. And so if the director said to the discussion forum, hey, Suite 201 is in arrears 3 months and we're planning to lien him, then this is something that would be a clear breach of confidentiality. And the consequence is that the director who discloses that confidential information has breached his standard of care. And if the director has done so knowingly, because you've warned them that if you do this, you're breaching your statutory duty of care, then they could be personally liable. So if the unit owner were to commence legal proceedings for breach of privacy, the condominium corporation would hold the individual director personally liable, and they would not defend them, and the person would have to pay out of pocket to defend themselves and possibly damages to the owner whose privacy was breached. Now, all of these consequences are pretty unlikely. In most cases, people don't usually sue over these things, but it does occasionally happen. So I hope that answers your question. But, it's very fact specific as to what would happen and what the consequences might be. But certainly, personal liability is a potential consequence of engaging in that. And Ron Britt says, hello. Hey, Ron. Good to see you. It's been a while. I haven't done one of these in a few weeks. I've had some other stuff going on. And we've had some people doing it like Tim and Dave Lella. So you've been treated to their excellent thoughts on these matters. So I hope that answers your question, Adib. It's a great question, and but it is very fact specific. So I think I sort of pointed you in the right direction, told you what are the different factors you would want to think about, and then as to what exactly is going to happen in your scenario, it's going to depend on the facts. So I mentioned this right at the top, the liability legislation. So the Government of Ontario passed legislation to protect for-profit and not-for-profit, i.e. condominium corporations, from legal liability relating to COVID infection if you are following public health guidelines. So that's a big if, because some people don't follow them, or they don't follow them correctly. And you have to be doing it in good faith and like best efforts, and so you have to be taking all reasonable steps to inform yourself as to what is required of you in terms of public health requirements. And if you follow them and someone gets COVID, you will not be liable. That's the basic idea of this legislation. It was proposed, now it's passed, it's law in Ontario. And is this a good thing or a bad thing? I think it's a good thing, and I'll tell you why. If you did not have this legislation, then you would have this strong incentive. Let's say if you're a condominium corporation, but it's really aimed at businesses, to keep everything closed, even though you're not legally required to do so. So, because you would be scared of liability. So take the example of condominium corporations that are maybe not in a lockdown region, so they might be somewhere where there's relatively low transmission, and it is legal for them to have their swimming pool or their gym open. If that's the case and it's legal, the board might be thinking, okay, it's legal for us to have the gym open, but if we open the gym and someone gets COVID and they blame us because they think it was from the gym, that's a risk we're not willing to take, and so we're going to keep our gym closed. And then you have this problem of like, the government is saying you can reopen, but people are refusing to reopen because they're scared of legal liability that is not connected to like an actual public health concern, but really just the liability and the cost. And the government didn't want that. So they wanted to say, look, if you're concerned about public health and you want to stay closed, that's fine. But we don't want you staying closed just because you're scared of getting sued. And so that's what this legislation is aimed at. It's aimed at stopping people from making decisions based on fear of legal liability as opposed to based on actual public health science. And to me, that's great legislation. And to the class action lawyers who criticized it, I think that's cynical because they have to think about what the legislation is for and not, what it's going to have, what effect it's going to have on their class action lawsuits. That's just my 2 cents. So that's the liability legislation rundown, and now we've got a question here from Angeline. So, hi Bradley, as per the new lockdown, are units allowed to do any renovations or just emergency repairs? This is a great question. Renovations are allowed under the new lockdown. There is a category called household services, and in household services, it talks about maintenance and repair, which would include renovations, and even non-emergency, non-essential home upgrades, things like repainting, which is sort of the classic example of not an emergency. You could paint anytime, is permitted. So that is allowed. Now, like I said, if your condominium corporation wanted to pass a policy that limited it, then that would be a reasonable thing to do, especially if the policy was aimed at noise control. And so, if you remember, all the way back to the first lockdown in the spring, a lot of people weren't going to work and they were working from home. And so because people were working from home, condominium corporations said, well, we need to do something about noise control and renovation noise during the day, because if you're trying to work from home and there's like hammering going on next to you all day long, that's very disruptive. It's not respectful of your neighbors. So we were not going to allow loud renovations that were going to be disturbing people. Part of it was public health, but part of it was also just like noise and nuisance. And so if you found in your particular condominium that a lot of people were working from home and that noise and nuisance was a big problem, you might say to someone doing a renovation, hey, you can go in and do stuff, anything that's not going to disturb the neighbors. But if you have, loud renovation work, we have to do it during certain hours, or perhaps you have to wait. And these are the kinds of specific policies that you want to think about, and whether you need them in your condominium community. Every condominium is going to be different, and there's no sort of universal answer to this stuff. It really depends on what's going on. So, long answer to a short question is that renovations are allowed under the lockdown. It's not like the first lockdown. More stuff is allowed. Dog walkers and house cleaning and all these types of things are allowed. But interestingly, social visitors are technically not allowed. So, I can have someone come into my house and paint, but I can't have a friend over. And you might say, hey, that doesn't make any sense. And you might be right, but that's just the way it is. You have to draw these lines somewhere, and no matter where you draw the line, in a sense, it's arbitrary. So you just have to pick a spot and do it, and as long as it's within a range of reasonableness, everyone just has to deal with it. So let's talk about electronic meetings. So electronic condominium meetings are still continue to be a big deal and the norm, and we're doing lots of them. We're sort of through the big crunch that we experienced in towards the end of September up until mid-November. So we do have pretty good availability in December and January if you're thinking of doing an electronic meeting. Of course, if you're thinking of doing it in February and March, we've got great availability for those. And you can contact us, as always, to book your electronic meetings. And a lot of people have questions about how electronic meetings work. So okay, we get a date and we are ready to do our meeting, and what do we do? And people have lots of questions, and everyone's questions are pretty much the same. And so we made a video, and Puneet made a video. She did an excellent job. If you have questions about electronic meetings, if you haven't done your meeting yet, and you're thinking about booking and you want to know what's involved, it's on the channel. We just put it up. You can watch Puneet's video. It's a how-to for the HLD meetings platform, and it explains step by step what happens from when you pick your date, your meeting date, so you book the meeting with us, right up until the day of your meeting. So it's not about what happens during the meeting, it's about how you get ready. And then, of course, what happens during the meeting we'll cover with you, closer to the date. But it's a wonderful video. It answers a lot of your questions. And if you still have questions after watching that video, of course, we're happy to answer them. And I'm also happy to answer them today in this session. So, question from Bruna. Since the rules of the current lockdown have so many gray areas and are sometimes in contradiction with each other, do you know if there will be any clarifications for the condo sector? Well, Bruna, we try to do that. So we do that every week. We publish our weekly newsletter, and we published it this Monday. The email went out at just after 10 a.m. on Monday, November 23rd. So if you're on the email list, you should have got it. And we spell out in painstaking detail exactly what the effects are on the condo sector, what you need to do, what you need to close, all of your amenities, how the gray lockdown works. And we also did a chart showing the difference between orange, red, and gray or lockdown. So we've got all that information available for you. And I agree that often the condominiums are forgotten when these regulations are written. And in fact, if you go read the regulations about lockdowns, the word condominium does not appear in the entire thing. And so we have to read them carefully and interpret them. And, we understand that sometimes different lawyers will read the same legislation and come up with different interpretations. That's understandable. That will happen on occasion for some of the restrictions. But for most of them, just about everybody agrees what they say. So, and if you're not sure, err on the side of caution and take the safer path. If you're faced with a path of doing something risky or more conservative and you're not sure, take the more conservative approach, and that's probably the right idea. So Adib has a question. An article came up making note talking about corporations enacting the rule of no visitors allowed. What are your thoughts on this, such as enforcement? Yeah, Adib, enforcement is, you're right on, man. This is the problem with saying no visitors, right? Is enforcing it. Someone needs to enforce. And so let's think about different ideas. You could do nothing on the one end, or on the other extreme, you could pass a rule, or in this case, more like an emergency policy saying for the duration of the lockdown, no visitors are permitted. That would be the most extreme. Something less than that would be saying that we're going to close visitor parking, subject to specific exemptions that you can apply for. That would be like if you can show a lawful exemption, we'll allow visitors parking. That's sort of like a little more passive way to do it. Even more passive would be an option to, send out a memo to owners saying that these are the expectations in the community, that there's an expectation that you will comply with the letter and spirit of the law, and that you will not have social visitors, but you're not actually going to enforce. And then how do you enforce? So, leaving aside whether your condo passes a rule or not, let's say that you receive something like a noise complaint and your security attends the unit, knock on the door, excuse me, could you please turn down your noise? You open the door and there's a party going on in the suite and you're in lockdown and you're in Toronto or Peel. And so this person is clearly breaching the existing lockdown order. What would you do? Who do you call? Do you call the police? Correct answer is you call 311. If you're in Toronto, I have to check if there's an equivalent or if it's the same number if you're in like Mississauga, Brampton. But in Toronto, it's 311. And that is the correct, so like City of Toronto information, and they will send a bylaw officer out to issue tickets. So that's how you enforce. Arguably, you don't need a rule that says no visitors. I think you could either enact a policy if you wanted to be really strict, or more likely, you just send out a memo to owners saying, this is already the law. We expect you to comply. If you don't, security staff are instructed to call 311 bylaw enforcement. So to me, that's the best way to do it. And I think that's the right balance if you're looking to be safe without being overreaching. or doing something that is more than what you need to solve the problem, really. So, hope that answers your question. Tova asks, quorum is 25% for a meeting of owners. If quorum is not achieved, is there a lesser quorum requirement when calling the meeting again? Yes, Tova, there is. But it's not until the third attempt. So you attempt the meeting at 25% the first time. You have to do a second attempt at 25%, and then on your third attempt, the quorum is dropped to 15%. So that is a mostly unsatisfactory remedy that is available to you if you've already failed twice to achieve your 25% quorum. I would say, Tova, if you're having difficulty getting quorum, then you can consider using a service that provides electronic proxy collection. And in my experience, owners are pretty receptive to filling out an electronic proxy by email for quorum purposes only, and that should help you get quorum at least on the second shot if you failed on the first. And in very rare circumstances, you go for the third shot and you get the lower 15%. But yeah, there's services available too, and you can get quorum. I know it's hard because people don't want to door knock because of COVID, and it makes sense. So, Bruna, I am on your email list because I was saying check my email, but I was asking whether the government is planning to clarify some of the rules or non-rules. I don't know if the government's going to clarify it, Bruna. We try and do that for you because we realize that just reading the large pamphlets that they put out or their news releases, or heaven forbid even going through the actual text of the regulations yourself is pretty dry, challenging stuff. And so we try to synthesize the information for you and present it to you. Just the key facts of what you really need to know as a condominium manager, and then hopefully that'll save you some time and add some clarity to your very challenging job of figuring out what's allowed and what's not allowed when they change the law on you every week. They do it to us too, and so every time, they publish the stuff on Friday, we spend all weekend looking at it, and we publish on Monday saying this is our take on it. So we get you that information as soon as we can. Some people want it out faster, but we want to take the time and make sure we get it right. Jerry asks, including the management company as a named insured in a condo policy is a standard practice in this industry. Is this a mandatory requirement? And if not, what are the reasons for doing so? It depends on your management contract, Jerry. So different management contracts will say different things, but there's usually a indemnity or a mutual indemnity in condominium management agreements. So it depends on the contract, and some managers are starting to include a term in the management contract saying that the manager has to be a named insured on the condominium corporation's liability insurance policy, and that is to protect the condominium manager and to ensure that if the condominium manager is sued for them doing their job in following the contract, but the owner or whoever is not happy, but the manager didn't do anything wrong, that the condominium corporation's insurer is going to respond at the insurer's cost and hire a lawyer and defend the manager. That's the reason for doing it. It's not mandatory unless it's in your management agreement to say that you agreed to do it. Sometimes there's also, you'll see the opposite in the contract, which says that the condominium manager has to take out liability insurance at the manager's cost and include the condominium corporation as a named insured in the event that the condo gets sued because the manager breached the management contract. So the manager was supposed to do something and didn't, and as a result, the condo gets sued, and then the condominium corporation wants to know that the condominium will be defended by the manager's insurer at the insurer's cost. And so those are the two sort of competing ideas here, and you have to look at your management contract and see what it says. And then whatever you agree to do in the contract, that's what you do. So that's the rationale, and it's not mandatory. It's case specific, Jerry, and I hope that clarifies it for you. on the question of indemnifying managers and insurance and who does what. All depends on what's in your management contract. Adib. A few bylaws introduced at the AGM did not pass due to not achieving 50% plus one. How long of a time period does the corporation have to achieve 50% plus one before the bylaw proposal expires? Okay, Adib, man, you're on fire today with these very thoughtful questions. So I have to give some background to our listeners so they know what you're talking about, because this is a pretty high-level question. So first, condominium bylaws pass by majority of all the owners, the owners of the units of the corporation. So taking the classic example, we're not talking about low threshold bylaws, we're talking about standard bylaws, like your operating bylaw, borrowing bylaw, standard unit, whatever. So you have 100 units in your imaginary condominium corporation. 51 units need to vote in favor of the bylaw, 50% plus one, right? So you fall short of your 50% plus one. You don't have 51 positive votes in favor in your 100 unit imaginary condo. Maybe it's because you only had 53 units show up to the meeting. So what happens? Well, some very creative lawyers came up with this idea that you could, instead of, because the vote has to happen at the meeting, right? So the answer to your question, Adib, is how long do you have? You have as long as the meeting remains open. So if you close the meeting, then you don't have any more time to go and get more votes. The bylaw fails and you've got to start from scratch. So to try and allow condominium corporations to pass bylaws that were popular, not controversial, but where you just didn't have the votes due to low turnout at your meeting, some very creative lawyers thought of this idea that you would not close your meeting, you would adjourn it to a specific date and time, and then in the interim period, while the meeting was adjourned, you could go and collect more proxies. And then you would have the vote at the return of the meeting. And the other thing you would do is everyone who is at the meeting, you don't hold the vote, right? So you come into the meeting and you've got X number of proxies and you've got X number of people in person, and then you say to all the people in person, go fill out a proxy and submit it, and then you collect enough proxies so that just by proxy you have enough votes in favor to pass the bylaw, and then at the return date of the meeting, you submit all the proxies, the bylaw passes. So this is a little bit difficult to do with a electronic meeting, but the basic, you have to rely on your chairperson to make the correct motion, and the chairperson has to adjourn your electronic meeting to a specific date and time, whereupon the electronic meeting will be reconvened and all of the proxies collected to date plus all the proxies collected in the interim period will be submitted to the meeting, and then your bylaw passes. And that is how you do it. And the amount of time that you have depends on how much time you set out when you actually adjourn the meeting. And if you don't do that, if you just say, okay, we don't have the votes, we're going to postpone it, and then you conclude your meeting, you've fudged it, and now you've got to start from scratch. So that's how you do it, and it's tricky stuff, and you've got to have a chairperson who knows what they're doing and is prepared and has the language of the adjournment motion ready and can pull it off in the moment. Pick a specific date and time, then you resume your meeting on that date, and you better have the votes. So that's how it works. Tricky stuff to try and get bylaws passed. I mean, it's a good idea if you can do it, but you have to do it correctly. All right, Rudy asks, how does one subscribe to your weekly newsletter? I'm not seeing it on your website. Oh, Rudy, don't get me started about the website. Killing me. Yeah, I know. We should have it on the website, but we don't. If you send me an email, bchaplick@HLD Lawyers, we will take your email and we will add you to our email list, and then you will get the weekly FAQ newsletter. And you'll get all our other updates, including the email that we send out that has the invitation to this live stream. So you're on the live stream, so you have some connection to the firm, but just send me an email and we'll get you on the email list. We'll just take the email that you send to me and we'll put it on the list. You can also send it to Bharat Kapoor, so BKAPOOR at HLDlawyers.com, and Bharat will add you on the list because I'm just taking your email and forwarding it to Bharat anyways. Okay, so that's how you get on the email list. William, if a board member has completed the CAO training course a few years ago, they left the board and have now returned, are they required to repeat it? No, as long as the training was completed within the last 7 years, they're good to go. So at some point, directors will be required to repeat their training, but not yet. Answer your question. Great question, William. And fortunately for me, a simple answer. I'm not sure if it's 7 years or 6. I think it's 7, but it might be 6. Anyways, but it's in any event, the requirement has only existed for 3 years. So anyone who's completed it would not yet be required to redo it. Thanks. Okay. Adib, board members being very difficult with the rest of the board and management in meetings is difficult. Board and management in meetings and difficult to reason. The meetings become unproductive. Is there any way of removing a director, even if there is no bylaw in place that outlines it? Well, Adib, there's really only 2 ways to remove a director prior to the expiry of the director's term of office. One is if there's something specific in your bylaw that has a process for removing a director, or if they cease to be qualified under your director qualifications. So, for example, Catherine had mentioned a director who didn't complete the training requirement within 6 months. That director was disqualified automatically. There might be other qualifications. And then the only other way to remove a director is to have a requisition meeting and have the owners vote them off. So that's your situation. And if that's not practical, then you're going to resort to other strategies to correct the person's behavior. And you should not hesitate to do that, to get the condominium lawyers involved, make sure that the director understands his or her legal responsibilities to cooperate and be a director who works in good faith. And if the person is not acting in good faith, then you might initiate legal proceedings about it. But in terms of removing a director, it's owner vote or whatever's in your bylaws. And I'll tell you a story. It's a real story. A case called Merle Hayes. And so this is a reported case, so I'm not speaking out of turn or describing anything that is confidential. It's a reported decision. You can go read about it, YCC 137 in Hayes. And I hope I get the facts right because I'm doing this from memory, but Merle Hayes had some psychological problems. She was on the board of directors, and she frequently threatened violence and even potentially attacked other directors. I think she punched one of the ladies and threatened to hurt her. And she also, had some weird hoarding behaviors. I don't want to be listener discretion, but I think she had dead cats in her freezer, things like that. Things that you would not associate with good mental health. So the Condominium Corporation, through its legal counsel, brought a court application for a restraining order against Ms. Hayes so that she could not approach or communicate with the other board members, and also to remove her from the board. And all of the allegations against her were proved by affidavits, and the judge accepted them as being true. And amazingly, the judge did not remove her from the board and said that they granted the restraining order and then created an exemption. It's funny and sad. Created an exemption to say that she could communicate with them in board meetings, and then said that the only proper way to remove her from the board was to hold a requisition meeting and have the owners vote her off. And I thought that decision really, to me, maybe it was correct to the letter of the law, but I think the judge might have missed the spirit of the law when the judge said that she could remain on the board even though she was attacking the other board members and punching them and kicking them and doing stuff like that. I thought that to me, I'm no judge, but to me, I would have taken her off the board. I would have just said, you know what, I'm going to exercise my discretion, and there's, we have to live in a society with rules, and if you're gonna attack the other board members, you're off the board. But this judge thought that just a warning would be enough. So that's the story of Ms. Hayes. Gives you an idea as to what it takes to remove a director. It's hard sometimes. It's hard. Okay, let's talk about health screening questionnaires. So, condominium corporations, like any other employer, have an obligation to ensure that certain people fill out health screening questionnaires every single day. And it's it's not being followed particularly well. And I just want to clarify for everyone who it would cover. So these are the people who need to be filling out health screening questionnaires when they're coming into your building. So every single day, any on-site property management and office staff needs to fill out a health screening questionnaire. Your superintendent, if you have one, custodians, cleaners, security staff, couriers, delivery workers, if they're making a delivery to the corporation, but not a delivery for a resident, and anyone who works for the corporation on a volunteer basis, and anyone else who is working on site for the corporation, landscapers, maintenance, repair contractors, plumbers, electricians, etc. Any of these people doing work in the building for the condominium corporation, they need to complete a health screening questionnaire before they're allowed to do any work on site. This does not include contractors who are attending the property to do work for owners. So people just aren't doing this. And, when we talked about getting your exemption from liability, if you're following public health regulations, this is an example of a public health regulation that needs to be followed, where you might need to demonstrate that compliance in order to avail yourself of the protection from legal liability. So if you want to have the benefit of that legal liability protection, which you do, make sure you are following public health guidelines, and not just the obvious stuff like the lockdown orders, but also everything that's being put into place thus far, including the health screening questionnaire for all of your on-site staff and contractors. So make sure you're doing it. Otherwise, you might lose your liability exemption, which you don't want. Do it. Eleanor, what is the board allowed to say at a requisitioned meeting for the removal of director? Reason for removal. You guys, man, today, everyone is on fire today with these questions. Okay, this is a really big problem, the reason for removal, because the Condominium Act says you're supposed to put a reason for removal. And so it's like you have to put it in the requisition, right? And in the requisition it has to say reason for removal. And so there was a case about this, Swan and Gone, which is like there's many decisions in this sphere of the Swan and Gone and DCC 45, many reported decisions. But one of them talks about defamation, specific to a requisition meeting. And what happened was the two board members wanted to remove the third. So the third director was, I guess, Swan, and so the other two directors wanted to remove Swan. They circulated a requisition, and in the reason for removal, which they were required to put, they just put like basic boilerplate language like director has failed to meet his statutory duty of care, like very innocuous kind of language. And Swan said, by circulating this requisition accusing me of failing to meet my statutory duty of care, you have defamed me. And so this defamation case went to court, and the judge concluded, and again, like, I can't believe this happened, but the judge said, like, yeah, putting this language in the requisition accusing this person of failing to meet the statutory duty of care is defamatory, and you can be held liable for damages. And I think the damages that they assessed were like nominal, very low, but it sort of raised this question, which is that you have to do this requisition. The requisition has to state a reason for removal, but anything you put in there could be defamatory. So you have to think very carefully in your circumstances what you're going to put in the reason, and are you going to put something that is like so bland and innocuous that it could not possibly be defamatory just to avoid legal liability, or are you going to put the real reasons? What are you going to write? And it's going to depend on your circumstances, and don't use this language that I'm giving you now. It's just trying to think about what might work. Like maybe you want to put something like a breakdown in the relationship between the board, or the board has become dysfunctional, or something like that, where you're not placing blame on any one person, and you're just like or even framing it as an opinion, right? In the opinion of the requisitionists, there is a breakdown in the functionality of the board, or something like that, just to try and make sure that you do not put something in there that you could later be accused of defamation. So, great question, and it's like a real serious problem. And there are amendments to the Condominium Act which I think will remove the need to give a reason for removal, and those changes, when they come into force, will be very welcome, because whoever thought it was a good idea to put the reason for removal, the idea is that the person who's being removed should have some sense of why, so that they can defend themselves. It was never intended that this would then be like a platform for suing someone because they try to remove you from the board. The idea was it's supposed to be a matter of fairness to the director facing removal to say, you're being removed because you did this. And the person can say, well, I didn't do that, or I did, or I'm sorry. And you can have a sensible meeting where you can talk about the impugned conduct in a rational and open way. But of course, that's not what happens, because condos. So, question from Adib. Can corporations retain multiple law firms as legal counsel based on their speciality, depending on the issue, as opposed to generally one law firm to retain and represent the corporation as general counsel? Sure, you can. Of course. I know condos that do it. You might have a law firm that is a condo boutique doing your AGMs and your general advice and your bylaws and your compliance letters. And then you might have some major development going on next door, and you want to get advice on the 150-story skyscraper going up next door to you, and you might use a different law firm for that. You might use a law firm that specializes in skyscraper development and municipal planning, and who goes in that's all they do. And you might use a different lawyer for that type of work, or you might, it's mundane, but you have a slip and fall on your driveway, and you're going to refer it to your insurance company, and they're going to appoint personal injury lawyers or personal injury insurance defense lawyers to do that kind of work. So different law firms or different lawyers for different jobs make sense to me, and there's absolutely nothing wrong with it. And it's when you're fixing your house, you use different tools for different jobs, right? You don't just fix everything with a hammer. Some things you fix with a screwdriver. And so, if you need a hammer, you call Doug Levitt, and if you need a screwdriver, you call Brad. And different lawyers do different stuff. And some law firms have different people who do different things, like us, who can handle 99.9% of all the problems that a condo would ever have. And some lawyers are sole practitioners, and they only do certain stuff, and you're going to have to go somewhere else if you need different types of files. So yeah, it depends who you're using. Totally reasonable. All right, so thank you, everyone. We talked about one more thing. So I'll sort of make this the last subject, unless we get some other questions. But Condo Buyer's Guide. So Condo Buyer's Guide came out earlier this month. It's available on the CAO website. I also put a link to it right at the end of our weekly FAQ. And it's really intended for condo owners, right? But what can you use it for as directors and managers? Well, it's a really great resource because it answers basic questions about how condos work. So if you have a owner, not necessarily even a new owner, but just anyone who's asking you, who's got a lot of questions about condos, and they want to know like what is a common expense? How are common expenses calculated? What are condo rules? Do I have to follow them? What does a condominium director do? You can point this person to the condominium owners or buyer's guide, and they have like a whole section on like the basics of condominium governance. And I would suggest that if you're a director, and I mean, if you completed your director training, this is probably the same information, but take a quick look through just so you know what's in there. It should all be familiar to you, but maybe not everything in there is. The information is presented in a very accessible manner, and I think once you know what's in there, you can refer to it as a resource when you're getting these types of questions from new owners and from others. So, getting a Amber Alert here. So I think it's a good resource, and you want to know what's in it so you can use it for your needs. If you're getting questions from new owners, from residents, from tenants, whatever, they want to know what a condo common expense is. Instead of you having to like painfully explain it to them, you can just say, oh, you know what, there's this buyer's guide, it's from the government, you should take a look, here it is, page 15, the perfect answer right there. And I think that that's something that you can do, and you can also just point them to the CAO website. So there you go. All right, well, thank you everybody. This is going to conclude the November 25th episode of Ask Us Anything. This was an amazing session. I thank you guys so much for those questions, they were great. Don't forget to subscribe if you're not a subscriber. I know I got some emails during the AMA for people wanting to be added to the email list. I will get you guys set up, and I will also flip the most recent one published on Monday back to you, so you have you're up to date, and then you'll get the future ones as well. Thank you, everyone. We'll see you next week. Stay safe, and as always, we're happy to answer